back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me today is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Morning, Mike. Good to be with you.
Good. It's great to have you here. I want to give a couple of shout outs at the beginning, or warnings at the beginning about a couple of things that are happening. Number one, you're going to notice throughout the show, Sam reaching out and touching his microphone. We're having some equipment problems today, and although we have new microphones and a new control center already here, the person that's going to be installing all that is coming next week. So we have a workaround, and it involves him having to press a couple of buttons pretty frequently through the show. So I hope that doesn't distract the people watching on YouTube. But other than that, this should go as normal, we're hoping. Okay, we hope that we've had a couple malfunctions this morning, and it's been a challenge. We've been in here over an hour, but we're hoping we can get this one done. The second issue I want to bring up is we're doing something entirely different today. We hope that we'll do more of these in the future. But today's show is going to be kind of a grab bag show. And we do dozens of probably, I don't know, we do lots and lots and lots of consultations every week with what we call PCs, potential clients. And in those consultations, we hear all sorts of stories and we give a lot of good advice. And so today, we're going to talk about, without naming names, of course, we're just going to give you some fact patterns that have come up in some of the recent consultations. It's kind of a grab bag of everything. And we're going to talk about the advice we gave and what, if anything, is happening in that case as we go. And we're going to touch on a bunch of issues. We are going to avoid a few issues because it conflicts with some of the episodes we have coming out very soon or that we're planning. So we're not going to talk today about any consults we did regarding AB 130, the balcony law, or special assessments. We're going to stay away from those. But I have no idea the 2, 3, or 4 that he's going to talk about today, and he doesn't know the ones that I'm going to talk about today. And I try to do at least one consultation a week, even though I tend not to do them because I run the firm. But I like to keep in the trenches, and so I do at least one consult a week. And so I'm going to tell a few of mine, and he doesn't know what I'm going to talk about. So with that, I'm going to let Sam take the lead on this. And then if I feel it necessary to jump in, I'll jump in. Sam, take it away.
Right. Thanks, Mike. I mean, you put it exactly right. We have so many of these, and they're all very interesting scenarios. One interesting one that jumps out to me I had earlier this week was pertaining to a San Diego community, small size, 36 homes, single-family residences, and this physician, PC, potential client, came to us regarding what was basically, and I'm going to keep it very short in terms of background and factual, kind of introduction of what's that issue. They essentially expanded their backyard fencing out into what constitutes common area portions. These are reserved maintenance easements for the association. There's a space that's intended to be a bit of a gap from the county for fire protective
But who
reasons.
owns the actual property? If the HOA has an easement, a maintenance easement, does that mean the doctor owns the property technically?
So he owns a property, but there's a reserved easement portion of it.
Okay.
So the association maintains that. The association has irrigation and sprinklers in that location.
Okay.
And then there's a cleared area that the county requires to remain clear as well. So there's quite a few moving parts to this. But in short, what they did was, and this took a moment to flesh out, but we realized that they had expanded 120 linear feet in width and 20 feet out, which constitutes essentially 2,400 square feet.
That's a lot.
That is a lot. So that's essentially the size of a house. And so that's very significant. Not only that, but there was also a lock component to a gate, which essentially deprived the association of access to this area.
Let me comment on something.
Yeah.
Okay. So as I understand what you're saying, we have a situation where the slope behind this doctor's home is technically owned by the doctor, but because the HOA has an easement and maintenance obligations, when it comes to easements, an easement is just a right to use somebody else's property, and it's limited to whatever is in the easement itself. Easements are usually recorded, and the rights to use somebody else's property are very limited to the uses described in the easement document. But what you can't do, if you're what's called the servient tenement, if you're the person that owns the property and somebody else has an easement onto your property, you can't block access. So by putting up a gate or a lock, he basically is preventing the HOA. Hold on, let me finish before you turn me off. He's basically preventing the HOA from doing from accessing the property that they have a right to access under the easement, and for conducting its obligations for maintenance and repairs, et cetera, and irrigation as well. Okay, and it was a significant portion. All right, go on.
Okay, so the key highlights, and I'll keep this very brief because I know we have other scenarios to get to, is they essentially locked out the association from access to this area, as you pointed out. None of the other homes in this association, none of the other 35 homes had anything comparable to this, not even in a negligible form. So they were the only one. There's no other precedent for it. There's no selective enforcement per se, which we probe into if someone else has been treated differently and permitted to retain these. And so what they received was essentially some initial notices. That was not productive, did not achieve compliance, and ultimately the association's legal counsel served them with an ADR demand. And this is basically a request for resolution to go to mediation, right?
And under the Davis-Stirling Act, meaning there's actual consequences if you fail to do it. Right.
Correct. Correct. So this was one of those instances under Civil Code Section 5930 of the Davis-Stirling Act. And so they came to us saying, okay, well, what do we do here, essentially? And the short of it was, look, the association will fight you on this. They're serious. They attempted a number of initial measures to
And they'll win.
And they'll win. And to initial measures to elicit your compliance, that was to no avail. And now they served you with this ADR demand. And the risk and downside of actually remaining entrenched in your current position, because you have put hardscaping. You've denied them access where they have a legal right.
They put hardscape.
They did,
So cement or bricks? Or
hardscape and then metal fencing on top of that, by the way.
Okay.
So I said, look, this is a losing proposition. And you can do it one of two ways. Either write it out, roll the dice, and you're probably not going to get a variance, which is to allow you to, either get retroactive approval or allow them to grant this to you subject to certain agreements, right?
Including taking over the maintenance and irrigation responsibilities.
And that's exactly the covenants. And I don't want to confuse the audience on that, although we've done fantastic episodes on that in our podcast previously. So the short of it was, look, this is a losing proposition. I can be telling you this right now or $10,000 or $15,000 from now, and it'd be the exact same proposition legally. And the other downside, real quick, and I'll wrap it up with those comments, is that if and when they prevail, assuming the fight carries on, which it most likely would, because this would be the first of its kind.
Yes, of course.
And it would set precedent for the community. So they have a lot of, skin in the game in terms of fighting this. So guess what? This PC would foreseeably be on the hook for attorney's fees.
Right. So what happened?
Once April. So
I'm on pins and needles.
So here's what they said ultimately. They are very thankful. And I didn't deliver them good news, but they were very thankful because they said, look, we had worked with a prior attorney, and this is someone who happens to be one of our competitors, and I don't mean that in any disparaging ways, but basically what they said is they did not explain any of this stuff to us. They basically gave us a bit of a pitch, and knowing this—
to get them to hire them.
It makes perfect sense, and he said, look, give us some time to just kind of deliberate on our next steps. We may either come back to you to help us negotiate an agreement as we work through resolving this. We totally see it your way. We agree. And they're smart guys. I mean, this physician and his brother at this consultation, they got it. And so I thought that went pretty well for them. And I think it'll probably, avoid some major pitfalls for them.
So before I go on to my turn, I'm going to just do a couple of takeaways. Is when people come to see us, we don't tell them what they want to hear. And our primary goal isn't to get them to sign up for our law firm and give us a retainer and hire us. Some other law firms do that. We don't. Our goal is to give them the best advice we can. And sometimes that's bad news. Sometimes it's you don't have a case. And if we tell somebody they don't have a case, obviously it'd be better for me if they did have a case. I'd make more money. But we don't do that. We tell them what the law is and what they need to hear, not what they want to hear. So kudos to Sam for that. Let me give one of mine, okay? I had a board member from an HOA in San Bernardino County, condominiums. This is I would call this a relatively small HOA, 80 homes, okay? Which I think anything under 100 is considered small. It's not teeny, like 6 or 7, but 80, okay? All condos. And apparently, and we did an episode recently, if you'll recall, a few weeks ago, we did an episode on management companies. And when management companies cross the line into handling non-delegable duties, for example. And, well, we had a classic situation here. We had a very small, unknown management company. I'd never heard of it, and I've heard of most of them. So this was a one shop. It was the owner that was the manager for this association. And this woman was not only remarkably ignorant about the law, which is one of the dangers, because you have to rely on your manager to do things that You, as a layperson on the board, a teacher, a cop, a doctor, a lawyer, don't know because you're not a professional board member. Like if you were working for a for-profit private company, you expect the board of directors at whatever, any corporation that's making a profit, you expect them to know their business. HOAs are very different. These are volunteers. They don't get paid. They look to the lawyers and the managers and the people that the HOA hires to advise them. They look to them to have knowledge that they don't. That's the point. This lady didn't have anything. So what was happening was, for example, she appointed herself as the inspector of elections for an election that was coming up. Okay, fine, whatever. We did a episode recently. I don't think I aired it yet, so it hasn't aired, but we did an episode recently on election rules and election laws, okay? One of the big things we talked about was the inspector of election has specific statutory duties under the Davis-Stirling Act. One of those duties, fundamentally, big important duty, is that it's the inspector of elections that must at all times maintain sole and exclusive custody of the ballots. So when the ballots go out, even though if you're not doing electronic voting, people can vote at the day of the meeting, most people mail their ballots back in the double envelope system. Those ballots have to be mailed to the inspector. They can't go to the board. They can't go to a homeowner unless the homeowner is the inspector. It has to be the inspector. Apparently, at the election, that this manager had appointed herself without, and the board, there's a couple of old ladies and this guy, our PC, who's now our client, by the way, hired us, but who are kind of just timid and they don't want to fight this person. And this manager is just got an overbearing personality. And so she kind of steamrolls her way over them. And what's happened is, and by the way, they're breaching their fiduciary duty by allowing that. Yeah. But what's happened is at the election, one of the homeowners who just happens to be friends with this manager walked in with all the ballots. And he, as the director, said, well, wait a minute. You're not the inspector of elections. She is. Why do you have these ballots? This is inappropriate. This is bad. And she said, no, the law allows me to designate someone. And no, it doesn't. It doesn't. And so the next thing that happened was, so they count the ballots. And then the director who's monitoring this, our now client, notices that a couple of renters have mailed in ballots. Renters, non-owners. We've done podcasts on this. Statutorily, Davis-Stirling Act, only members of the HOA designated as recorded owners. There's a public record demonstrating they own at least 1%, right? Only owners can vote or sit on the board or run for the board, okay? Not renters. Now, that wasn't always the case, but the law changed several years ago, and that's the law now. This director pointed it out. And this manager said, no, the renter was designated by the owner to vote in their place. In other words, a proxy. Mm-hmm. That's very illegal. When it comes to the Davis-Stirling Act and HOAs, you have to designate another member as a proxy. You cannot designate a non-member. This person, this manager, and I'm saying that loosely with air quotes, is supposed to know better. So he pointed that out and embarrassed her at this meeting. And at the next meeting, she, the manager, brought up to the other two cowed directors, we need to censure this other director. And they censured him, and then they've now locked him out of all executive session meetings. Completely illegal. I am going to be visiting hell on this person. When this lady at this nothing management company gets our letter, if she knows what's good for her, she's going to snap to it. We're going to do a recall and get the entire board replaced, get people on there that are more competent. And then the first thing we'll do is terminate that contract because she's also told them they can't terminate without cause. And she's limited to what cause could be. I don't think so. So anyway, we're going to fix this, but we'll keep you posted in the future. But that's how important having a management company is. So anyway, needless to say, this guy hired us on the spot and we're going to take care of it. And that was yesterday. Sam, give me another one.
Well, that was unbelievable and fantastic. And I'm glad for this person that they have good representation now.
Oh, and I'm going to let you have that case, by the way.
Oh, okay. Yeah. Then impeccable.
You didn't know that, but
then impeccable representation.
Yeah.
Okay. All right. Thank you. Okay, all right. Another one I had was about a week, maybe a week and a half ago. We had a veteran who was honorably discharged, suffering from PTSD.
Okay.
She shared this with me, who has a service animal, has a dog that's a service animal. And
Well, let me stop you. So we just recorded an hour ago, it hasn't been released yet, or 2 hours ago, I should say. We just recorded an episode where we went into tremendous detail about the difference between service animals and emotional support animals and the protections that are offered in HOAs. So this is going to touch on an episode that may or may not come out before this one. We don't know yet. So you can look if there's an episode, because I've done shorts on emotional support and service animals, but not a full-length episode. We just did that, so we'll see. But go ahead.
Yeah, so basically a service animal is under the law, in short, and you'll see this in the shorts and when the full form episode releases, has a protected status. They are highly, and they're severely scrutinized. In short, they are not deemed as pets, normal pets. These are more medical assistive devices.
They're considered wheelchairs.
Like wheelchairs, essentially, right. for people suffering from various disabilities. Okay. And so in this case, this veteran suffering from PTSD had a legitimate need for it. This was, disqualified as a service animal.
So it was trained for a specific task.
Correct. It was trained for a specific task, so this was not merely for emotional support. It was really there to perform a task that was necessary, like a medical device, a disability device. She took our dog to one of the amenities, specifically the pool area. The dog was not swimming. The dog was next to her. She was, I think, at one of the lawn chairs. And the manager or someone affiliated with the manager, a representative, comes to her and essentially berates her in front of everyone. She was very embarrassed. It triggered certain, stress-inducing reactions in her, and she was admonished and said, you can't have this dog here. Pets are not allowed.
Did she tell them this is a service animal?
She did. Not only that, but even though you're not required to actually, have a specified collar or vest or designation that it is a service animal, she happened to have one on it. So not only did she mention this to this representative, but she pointed out, said, look, that's a service animal. I've also provided the board a prior registration form to this effect.
Which you don't have to do under the law. They can't ever, I'll give something away that's in our other episode. There's only 2 questions when it comes to service animal, not emotional support, okay? A service animal, there's 2 questions your HOA can ask, and that's the end of their inquiry completely. That's it, over. 1, is this a service animal? And 2, what service does it provide? That's it.
So in this case, she was unaware of that. She didn't have any prior legal guidance. She was unaware of her rights. So what she had done was she had, as part of a broader pet registration, she had submitted a detailed, but it had addenda and details that this was in fact a service animal. She had her medical.
She went way beyond what she was required.
She was not even required to produce any medical record, but she had volunteered all of that up front. Okay. And despite that, notwithstanding those efforts, good faith efforts by her end, volunteering, oversharing, she was admonished. She was berated. She told to leave. She was embarrassed. She was told to leave, and she left. She didn't have to leave, but she left. And then essentially what she did was send the board a follow-up correspondence. Good. Hey, I did this. So she documented it, and then she came to us for the consultation. In short, here's what I said to her. We covered all of the law that we discussed and that you also contributed. We said, look, you didn't have to do A, B, C, D, yet you did, okay? Under the law, the service animal is not a pet yet, okay? They're treating it as a pet. They conducted themselves extremely wrongfully in that dynamic.
Violation of federal and state law.
And they're in deep trouble for it.
Yeah.
Here's what she wanted to do. She didn't want to necessarily jump to a legal escalation. She said, what I want to do is I just want them to acknowledge it, leave me alone, and never repeat that mistake. I don't want to necessarily pursue them just yet. I want to be kind of more amicable. So what she did was she requested an IDR, and she said, let me see how this goes. If they acknowledge their wrongdoing, if they basically stand down, good. If not, I'm coming back, signing up with you guys, and we'll pursue them.
And I will tell you that the HOA will get creamed. It won't go far. It's not going to go far. As soon as they get their lawyer involved, assuming the lawyer has an ounce of competence, and I'm not even saying a competent lawyer, just an ounce of competence, this will end very quickly with a sincere written apology that we will read on the air, okay? Because This is so bright line, slam dunk, black letter law. I don't know what other synonyms I can use. This shouldn't even be an issue we're discussing at all. It should never have happened. I mean, I'm stunned.
And just to add one more nugget, the optics of it would be terrible. I mean, this is a veteran, PTSD, and this is not even a matter of gray
combat veteran,
a gray area of credibility. This is slam dunk, unequivocally. She has a service animal. It's nothing else, and you guys at X, Y, and Z.
Unbelievable.
Emotional distress, arguably, in this case. It's that outrageous.
Okay. I'm going to give you another one now. My turn. Okay? All right. So we have a client, now a client. I gave it away. Sorry, they hired us. But we had a PC come in, and this was about 6 months ago. We had a PC come in and lives in a house that's valued at a little over $2 million, has a good size yard. I would say totals, I think, a half acre, right? But behind this person's house, and this is in Lake Forest, okay? Behind this person's house is like 200 or 300 acres of, there's a river that actually flows during the water season, right? But when it's not a river, it's a dried bed. But there are thousands of eucalyptus trees and big tall trees, okay? It's like a forest. It's beautiful back there. You don't hear any of the traffic from some of the busy streets like El Toro or whatever. You don't hear any of that. It masks, you can't see other homes like in other neighborhoods. It blocks everything. And it's beautiful. And he plays with his dogs out there. He hikes every day and does that sort of thing, okay? These trees have been there. He's had the house for 20 years. Trees have been there since before he moved in, okay? And we're talking lots and lots of them. And it's all owned by this HOA. The HOA went in without any notice to the homeowners, without any vote, of course, because there's no notice, involving the homeowners, no discussion, went out and cut down 200 or 300 of those trees right in front of his back of his house, right? Because it's his back porch that opens up into this beautiful, I don't even know what to call it, a glen or something, right? Just chopped them all down. Now, of course, it's much louder. There's a throughway all the way through to the next neighborhood, so you can see the houses there. And so, of course, all this noise coming in. It is a blight. It looks terrible. Now, those are components. Those are major components. They don't require maintenance. They don't get watered by the HOA. It's natural rains and other things, but they're valuable because they're all full growth, mature. They look. We went to the property and looked at it. They look to be over 100 feet tall. I mean, they look tall to me. These are big trees, okay? And we're talking about a lot of them. It's created a view blight and a noise blight right now. That is a violation of the Davis-Stirling Act. That was something the HOA needed to get permission from. So we met with this person. We said, look, your HOA stepped on some toes here. This is something that should have been brought up in discussion-wise to your community. And they didn't do that. And so we think we'll be able to force them to plant the trees. We ended up, and you know this, even though I gave this to one of the other senior associates at the firm, we ended up sending a demand letter. We were heading over to mediation, but before that happened, the HOA actually agreed to plant 100 mature trees in or near the spots where the trees were, okay? At great expense to the HOA. Now, we could have fought with them and said, look, you better exempt him from any. It turns out they didn't need to do a special assessment. They borrowed it from reserves, but whatever. Point is, we could have argued that and said, it's better not come out of his pocket. But our client says, I don't care. I'll pay my fair share if they ever need to do an assessment to replenish those reserves or whatever. I don't care. I just want my trees back. Now, he knows they're not his trees, but they're the trees off his house, right? So that's how he referred to it. But I want those trees back. And he got them. And they've already started planting them. They can't do it all in one day. I think it's a lot of work. These are big trees, and they have to be trucked in. Now, they aren't going to be the 100-foot. They're going to be less than that, but they're still mature trees. So it won't be long, I guess, maybe a decade before they're back. But they're big enough to block view and noise. Yeah. Okay? You can get a lot with a 20-foot tree, So I don't know what the size are going to be because I haven't been back to look, but I know they've already started planting them, and they agreed to do it over a period of like 4 months. Okay, so it's happening over a 4-month period, and so we actually got that pretty quick, and that's happening now. The HOA is in compliance, and to be honest, to give this HOA credit, they didn't realize, their management company didn't tell them anything. I guess they didn't ask, but they just did this. They didn't realize that they couldn't do it. They didn't know, and they were actually. I'll give them credit for looking at what we wrote. We wrote substantial ADR demand. It was 15 pages, citation of lots of cases and statutes. We had pictures that I went and sent our assistant to take lots and lots of pictures and walk through this area. We happen to have pictures of what it looked like before, because he'd had a lot of family events taken off that back balcony or porch, and you could see all the lush trees. And so anyway, they were very apologetic for it. So this is an HOA that didn't do this maliciously. They just were ignorant, and they accepted that. And so this is an example of a good HOA. Yeah. So they did a bad thing, but they didn't do it to be bad. They did it because they didn't know. Yeah. They should have known, but they didn't. That's okay. But when they realized their mistake, they did the right thing. Right. And I give them credit for that.
Yeah. I mean, they absolutely deserve credit for that, for doing the right thing, but what a costly mistake. And,
a lot.
And a fantastic result for our client. And I mean, I think you mentioned this, but I mean, that also is something that enhances his property value because of its specific location. So in his wisdom, he realized that and said, look, I'm not really that, preoccupied with whether they eventually especially assess me or not to reimburse the borrowed money from the reserves or not.
Right, I'll pay my fair share.
Yeah. So kudos to him and a great result on his behalf.
I think we have time for one more, Sam. I'm going to leave it to you.
Oh, okay. Thank you. So I'll make this one brief. This was one of the potential clients' PCs where I did a consultation where he came to us specifically for guidance. We knew in advance that this was not really an engagement or retention type of dynamic, although at times both sides, to their own surprise, will kind of pivot to that, because if more things kind of get come to surface or they become more aware of, let's say, a misconduct by the association.
Okay, you're killing me. Tell me.
They might change their minds. But long story short, this gentleman, really nice guy. This was a LA County property, single-family homes, mid-sized community. I want to say about 180 homes, if I recall correctly. He essentially displayed an American flag that was 4 feet by 6 feet in dimensions. 24 square feet. Okay. He got a letter, initially a courtesy letter from the association, and then it became much more contentious. Okay.
Let me say something here, Sam. So we did a recent podcast, and I think we released it already. If we haven't, we will soon, but I think it's out. We did a podcast on signs, banners, and flags. Yeah. One of the things we talked about is on banners and flags is size 15 square feet. Anything 15 square feet or smaller is completely protected. If it's a political flag or a flag that demonstrates non-commercial, if it's a non-commercial flag, you have a right to fly it if it's in that size. But 24 square feet's beyond the statute. When it comes to signs, 9 square feet. I want to let everybody know that that's in the Davis-Stirling Act. Okay, so go ahead.
Which, by the way, is also consistent with the U.S. Flag Code, and so
right.
So that's been established, and case law has upheld exactly that. 15 square feet is the operative size. So I mentioned this to him. We walked through all the details and looked at the governing documents, the rules that were adopted, and essentially discussed all of that. But he also had some other incidental issues, such as, during various local and municipality campaign seasons, displaying a bunch of, banners and signage, yard signage. And we talked about what they can and can't regulate as far as materials, signs, dimensions, and also duration, location of it. For instance, your yard versus, let's say, common areas. You can't have them in common areas or in the amenities, right? I mean, you can't put it on a clubhouse roof, for instance. I mean, that's
wall of a condo.
Yeah. And we even, in our podcast, jumps into a lot of details, but I also mentioned to him, look, for instance, if you had a for sale or sold sign relating to your property, that's protected. State law permits you to do that on your lawn, on your home, which a lot of, but kind of distinguish that from, let's say, commercial or advertisements, which then the association can regulate. That being said, he understood that. He recognized that. He said, look, I'm going to try to work with them, see if they'll make an exception for me. And whether they do or not is a separate issue. But he understood that this 15 square feet limitation on the flag versus his 24 square feet, there's a market difference there, right? And then the other thing that he was somewhat confused by.
Before you go into that, I know what you're going to say, because I remember talking to you about this case. I'm now. We chatted when this consult came in, and I remember this. I don't actually want you to bring up the other issue. It's going to open up a whole set of things that we don't have time to discuss in this podcast. I want you not to mention it. Let's save that for another time. But I will say, you brought us 2 examples where we told the person that they didn't have a case. And I don't know if you're giving me a hint here, if you want people to be scared away, but we tell it like we see it. But what was the long and the short?
Well. Okay. So you obviously focused on the ones where we retained. I kind of pointed out the ones where it was more of a legal guidance question and answer format, right? And you also, I mean, we have an ethical obligation to tell them when they have a case. So in this case, you know, the flag being 24 square feet, it's a pretty straightforward dynamic, right? I mean, you tell them, look, you know, we could argue for you, we can attempt to negotiate.
HOA can regulate it,
but
we can't
but
stop
they
them.
can, right? So so the other part of it was that, you know, and with this guy specifically, he also said that he had somewhere in the vicinity of 3 dozen signs. Okay, so then you cross into this reasonableness versus unreasonableness part of it. But yeah, we have numerous other instances in PCs where they retain immediately. Yeah. Those are typically, and I'm kind of breaking our rules here, and without getting into specifics, I will just kind of delineate like what types of cases typically lead to more immediate retention. And we have water intrusion cases where there's an immediacy element of it. We've discussed that in various podcasts. You know, people come to us. We have instances where they come where they're basically at the eve of either a very serious enforcement, such as, let's say, someone's accusing them of harassment, or they were served with an ADR demand. And that's immediate retention, right? So we jump in and we essentially get up to speed and either represent them in court or at a mediation, pre-lit, right? Okay. So I'll just leave it at that for now. But yeah, the intent was not to scare off people and say that, look, we will kind of tell you what you can't do. But there are good HOAs and bad HOAs. When the HOAs are within, you know, operating within the parameters of operative law, state and federal, and the Davis-Stirling Act Civil Code.
And their governing documents.
I mean, you kind of have to look at the interplay between those and let the clients know. And I would say I really want to credit us for this because I've seen the competition. And we are scrupulous, conscientious attorneys. I think we have a heightened emphasis, and I credit you for this too, because you, at the top, you put a focus on this, and you've kind of given us license to approach it in that manner too, which is, look, if we have a legitimate claim, if there's a colorable claim, right, there's a legitimate basis for it, we tell you the options. We tell you the options of A, B, and C, and then we trust you enough and we respect your judgment enough and intellect enough to make an informed decision, okay? So sometimes that means someone will try a thing or two, like such an IDR or documenting their claims, and then they come back to us for a second consult or to engage. They'll request a fee agreement. In other instances, they'll jump on right ahead and they say, look, you know, I'm not entirely comfortable handling this part of it.
You do it with me.
You know, you do it with me. And then we're happy to get involved and represent.
Okay. Well, thank you. Thank you for that. So we kind of hope you like this little format, just real loose discussion of some things that are happening in real time, the things that come up. I'll try to do this again because I kind of think there's a value here to it. But either way, thank you for the compliments. I wasn't fishing for those. We do value. We think that we're ethical. That's certainly something that I stress a lot, and I believe it's better in the long run to you know, if tell a client they don't have a case. If they don't, save them a lot of money because they'll come back if they need us in the future. And so you know, that's not my primary. My primary goal is to give them accurate legal advice, not just to get them to sign up. I don't offer, you know, incentives to my lawyers to get people to sign up. We don't do that, okay? If you like this episode, please hit the like button. And if you haven't already subscribed to HOA Hell, please do so. If you want to ask a question or leave a comment, we'd love to hear from you. Until next time, have a wonderful day.